This afternoon's hearing on the Committee on Health and Human Services. We'll be hearing a total of 6 bills this afternoon in an order other than what has been published. We're going to start with LD 934, then go to 497, 760, 762, 837, and finally 606. That is subject to change depending upon connections and whose schedule takes precedent, but we have a number of people who are stepping in and out. So if you'd like to watch as well as listen, you can go to the YouTube channel at legislature.maine.gov, look up Health and Human Services, and you can find a link to our YouTube channel. We'll be hearing from witnesses. We ask that whatever name is designated under you corresponds with who you are so we can find you readily. And written testimony can be submitted anytime up until we vote on the bill. And the time limit for contributions for testimony is 3 minutes. That's about 1.5 pages of typed material. I did want to mention again the technical challenges. There have been plenty today for all the committees, mostly related to connectivity. And with the wind we've got today, there are people who are dropping electricity, dropping wireless, dropping internet. So we'll make it work. It may be that you have to call in at some point if you're testifying. So let's introduce the folks who are already here. And we'll start with Representative Zager.
Good afternoon. Thank you, Mr. Chair. My name is Sam Zager. I am honored to represent District 41 in Portland.
Representative Lemlin.
Good afternoon, Senator. My name is Michael Lemlin. I represent House District 88, Chelsea, Jefferson, Whitefield, and part of Noblesboro.
Representative Perry.
Oops. Good afternoon. I'm Representative Perry, Ann Perry. I represent House District 140, which includes Indian Township, Baileyville, Bering, Calais, Charlotte, Robbinston, Perry, Pembroke, and Pleasant Point.
Representative Craven.
Thank you, Mr. Chair. My name is Margaret Craven, and I represent House District 59, which is part of Lewiston.
And Representative Javner was here for a bit. Okay, we'll come back to her. Senator Moore.
Good afternoon. This is Mary Ann Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
Representative Javner, are you reconnected? We'll go to Representative Meyer.
I can attempt. This is Representative Javner. I represent House District 141, which is located in Penobscot and Washington County.
Thank you. Representative Meyer.
Yes, thank you, Mr. Chair. I'm Representative Michelle Meyer, serving Southern Maine's House District 2, which is all of Elliott and parts of Kittery and South Berwick.
Welcome. I'm Ned Claxton. I represent Senate District 20, which is Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. We've had a request we also have our able staff here. So I'll let Ms. Dooling introduce herself.
Good afternoon. My name is Erin Dooling. I'm one of the legislative analysts for the Health and Human Services Committee.
And Ms. Withy.
Good afternoon. My name is Carrie Withy, and I'm the clerk for the Health and Human Services Committee.
So if you would let Carrie, if you would let in Representative Laurel Libby and the other person who plans to speak to LD 934, we'll get started with that testimony. Representative Libby, the floor is yours.
Thank you so much, Mr. Chair. Good afternoon, everyone. Senator Claxton, Representative Meyer, and distinguished members of the Committee on Health and Human Services. My name is Laurel Libby, and I reside in Auburn. I represent House District 64, which is Minot and part of Auburn. And I come before you today to present LD 934, an act to create a family and juvenile mediation program within the Department of Health and Human Services. This bill establishes a family mediation resource program within the Department of Health and Human Services to support communication and conflict resolution between parents and children as an alternative to mental health services or the court system. At times, family situations can be complex and even messy. And sometimes the issues that families are dealing with don't necessarily fit in the mental health category and aren't appropriate for the court system. So who might a family turn to for help in that situation? The answer to that question is not always clear, and that can leave a family without the resources to address the issues that they're facing. By establishing a family mediation resource program, we can ensure that these families don't fall through the cracks and hopefully prevent small issues becoming larger ones that might have to utilize mental health services or the court system. While I am pleased to introduce this bill, I am not the expert on the issue, and so I would ask to cede the remainder of my time to Elizabeth Shardlow, with whom the idea for this bill originated and who will be better able to answer any questions you may have. That said, I'm happy to answer any questions.
Thank you, Representative Libby. Are there any questions for Representative Libby before we go to Ms. Shardlow? I don't see any. Thank you for being here and for introducing the bill. So, Ms. Shardlow, if you want to take yourself off of mute and join us, we'd like to hear from you.
Great, thank you. Can you hear me okay?
We can.
Fantastic. Good afternoon, Senator Claxton, Representative Meyer, and distinguished members of the Joint Standing Committee on Health and Human Services. My name is Elizabeth Shardlow, and I live in Kennebec County. I asked Representative Libby to sponsor this bill because Maine parents currently have nowhere to turn to for help in navigating challenges with their children until they enter the court system. Unless a child is suffering from some sort of mental health related issue, parents have no resources available to help them resolve conflicts within the family. The state of Maine has long recognized the important role that mediation plays in dispute resolution by not just offering it, but in most cases requiring it of those individuals involved in family court matters, as well as in juvenile court cases. Yet there remains a bar to access, and that bar is action significant enough to require court action. Outside of family matters in juvenile court, the only way for a family to access mediation services with their child is when the child files for emancipation. Obviously, it would be more beneficial for the outcome of all involved to resolve family disputes before emancipation becomes the only option, or the juvenile ends up either incarcerated or on the street. So what is mediation? For those who aren't aware, mediation is a confidential and voluntary process. It is not counseling. In mediation, a neutral participant assists the parties in resolving conflict by facilitating their discussions, opening up the opportunity for peaceful expression of divergent views, reducing resentment, improving understanding and communication, clearing the air, being truly heard, and improving relationships. Mediation is usually felt to be a transformative process. Where pain and dysfunction once existed, parties who successfully mediate their disputes find that bridges of communication are built, and the neutral's ability to help them reach a mutually agreeable solution means that they both win. Instead of compromising, they collaborate with the other party to reach resolution. The parties that come to mediation control the process. The neutral does not take sides, but rather asks clarifying questions and listens actively while guiding the parties through the resolution process. Family mediation, especially with parents and teens, can have a profound impact on reducing delinquency and strengthening the family. Mediation is a non-adversarial process. From the perspective of the juvenile, mediation offers the only real opportunity to address their issues without adults teaming up against them. Because the mediator is a true neutral, the juvenile can work through their conflicts with their family in a way that truly allows their voice to be heard. Similarly, parents can address issues with their child in a confidential setting without the concerns that what happens in mediation will be used against them in some way, for instance, in court or child custody matters. Mediation is a confidential process which helps the parties come together to work out their differences. The mediator does not take sides or give advice, but again, they ask questions to clarify, restate what the parties are experiencing, and help the parties work through effective communication. Every state in the nation offers mediation services through their courts because we have long recognized the important role that mediation has in avoiding the costly and challenging ordeals that otherwise are inevitable in court actions. 20 years ago, access to mediation for youth and families was addressed by the 120th Maine legislature, An article in Juvenile Justice Digest from 2002 describes LB 1237 from the 120th, where the effort was made to address homeless youth. And the article stated, and I quote, "Social welfare authorities believe early counseling and family mediation can fix problems for about 2/3 of the youth," unquote. As a result of that initiative, we now have shelters for homeless youth, which help to address their needs after they have left home. But family mediation is still not available as a proactive measure to help prevent them from ending up on the street. We have the infrastructure in place through the courts to offer mediation, and we have the funding already appropriated for this service. By creating a program within DHHS to simply coordinate referrals to the mediators already employed by the state of Maine, not only can we avoid a fiscal note, but ultimately there's a good chance that this type of program can actually reduce the burden on the court system, thereby reducing the state's expenses and addressing the negative outcomes that we are currently seeing, all while strengthening Maine families and improving the future for our youth. A very important note, and that is the question of why we wouldn't want this to be a court-sponsored program. I'll offer my thoughts on that and why I specifically requested that it be done through DHHS.
Can you wrap up your comments now?
Yes, absolutely. DHHS's motto is the Maine Department of Health and Human Services is dedicated to promoting health, safety, resilience, and opportunity for Maine people. There's no better way to provide resilience and opportunity to Maine families struggling with dysfunction, parents struggling with challenging teens, and teens struggling to navigate the tumultuous phases of adolescence than to help open the lines of communication and afford these Maine families the opportunity to resolve their conflicts. It is my sincere hope that this bill will simply close the gap by removing the barrier to access that currently requires judicial intervention before families can get help for their kids. By creating a mediation program through DHHS, parents seeking help can access services and meaningful intervention without the necessity of a mental health crisis or the stigma associated with mental health counseling, and Maine youth can seek conflict resolution with their parents in a way that is meaningful and transformative. By the time they're on the streets, it's usually too late. So I thank you for your time, and I welcome any questions that you may have.
Are there questions of Ms. Shardlow? You obviously have some expertise in this area. Were you planning to submit your testimony electronically?
Yes, I'll submit my testimony, and I also have a list of resources that detail what other states have been doing. There are several other states that have similar programs that they offer free to the public, and I have a list of those that I'll submit as well.
My father was a mediator, so I have a soft spot for mediation. So if you could
Fantastic.
submit that, that would help the committee do its work when we get
Yep.
to the work session.
I will do that.
Representative Craven, you had your hand up.
Thank you, Mr. Chair. Thank you very much for all of the, for your testimony. I have
Sure.
two questions, actually. One is if you would tell us what triggers the service and also if it's means tested.
So the service can be, the idea is that, so currently the only way to access it is through the courts. If you have some sort of court matter before the court, they will offer or in some cases require that you go through mediation before you get to hearing.
I
And
am
go ahead.
familiar with that, but I just wanted to, how does any family access the service and what would trigger the service being offered?
Currently,
Yeah, no, in the bill.
it would be through referral from law enforcement, a guidance counselor, school resource officer, pediatrician, or a self-referral. And the successful programs in other states, there's no specific person that you have to get a referral from. They allow self-referral, although most of the referrals do come from the court system.
Representative Javner?
Thank you, Senator Claxton. I have a question, Ms. Charlo, concerning the age of these services. I had a constituent call me with a very similar concern of this, and what is the age limit that is set, even in this bill before us for the mediation process? I know that sometimes, once a child reaches a certain age, that there's no longer anything the parent can even do. So how does that play out here?
So the states that have programs that I was able to identify an age range or target range, it was 6 to 17 or 8 to 17. And so mediation, also is not, because it's not counseling, the skill set that is required of it doesn't necessarily require direct experience with, for instance, obviously kids are not just small adults, they act differently and they talk differently. It doesn't necessarily require experience with young children. Obviously that would be helpful, but because of how the mediator operates, the process itself doesn't, by its very nature, have an age minimum or maximum. And so again, through a program like this, there's no binding decision. There is court mediation, where you can reach a binding agreement, but on a self-referral basis, a referral from, a guidance counselor, for instance, the resolution is what the parties come to. It's not, there's no action mandated based on that, those decisions that they make. So there thus wouldn't be an upper age limit as far as, parental control, if you will.
Okay, great. Thank you.
Okay.
So I don't see any other questions. Thank you for being here, Ms. Shardlow, and we look
Thank
forward
you.
to seeing some additional documentation from you to help us with reviewing this bill.
Fantastic. Thank you very much.
I don't see anyone else signed on to testify for. I don't see anybody. I do see Dr. Landry has submitted some written testimony, and it's not clear to me whether he wanted to speak to this or not. Well, while we get him in the room here, I'll give Representative Stover a chance to introduce herself.
Hit all the buttons at once. Good afternoon. My name is Holly Stover. I represent House District 89, including the towns of Booth Bay Harbor, Southport, Edgecombe, Westport Island, and part of South Bristol. Thank you.
And Dr. Landry you don't look like Dr. Landry.
Surprise. I used his link to
Okay.
join, but I don't believe he was planning to speak to this, although he is.
Okay, he just joined the meeting, so we'll give him a chance to speak or not, as you wish.
Thank you for the opportunity. I think our letter speaks for itself. We do not have a act position on this bill, but wanting to provide the information to the committee for their information.
Okay, thank you for that. So I don't see any other people interested in testifying on this bill. I don't see any hands up. So that'll conclude the public hearing portion of our consideration of 934. Are there any questions we have for Ms. Dooling in anticipation of the work session? I heard reference to some monies being available for this program and the court system having some capacity. I'd like to have a little bit better understanding of whether the court thinks they have the capacity and what monies might be available to help support the program. Senator Moore.
I was thinking too, if there is any other states that have already have it, and I think she mentioned that, maybe getting an idea of how it works in some of the other states would be a good thing to look at the work session as well.
I'm thinking that's going to come with her submission, but yeah. All right, I don't see any other questions. That'll conclude that portion of 495. I'm sorry, 934. Did Representative Madigan join us, or do we want to wait for her to come in and have Representative Meyer go with your bills? What's your preference, Representative Meyer, since you're here?
I don't see Representative Madigan. She has not responded to my text, so she may be out of power or en route. So I'm very happy to move forward with 762.
Thank you. The floor is yours.
Okay, thank you very much. Good afternoon, Representative Claxton, esteemed colleagues of the Health and Human Services Committee. I am Representative Michelle Meyer, proudly serving House District 2. I was asked to sponsor this bill at the request of the department. LD 762 provides clarity to definitions in the Child and Family Services and Child Protection Act, updating cross-references to Title 20A. Dr. Landry will be speaking after me, and I ask you direct any and all of your questions to Dr. Landry.
So I'm not inviting anybody to ask any questions, and we'll go. We'll go to Dr. Landry.
Thank you, Senator Claxton, Representative Meyer, members of the committee, and our thanks also to Representative Meyer for introducing this bill. I'm Todd Landry. I'm the Director of the Office of Child and Family Services within the Department of Health and Human Services, here today to help introduce and testify in support of LD 762. This bill amends definitions in the Child and Family Services and Child Protection Act to, as you heard from Representative Meyer, update cross-references to Title 20A based on changes made recently to the truancy statutes. This bill, we believe, is fairly straightforward in that it seeks to correct the cross-references and ensure OCFS retains the authority to intervene in situations involving truancy as defined in Title 20A. In addition, OCFS is requesting the committee consider an amendment to the current language of the proposed LD 762. Specifically in Section 3 of the bill, at the end of the sentence that currently ends with reference to paragraphs C or D, we propose inserting additional language of, quote, when truancy is the result of neglect by a person responsible for the child, unquote. The department originally drafted this bill in early September of last year. And since that time, we've experienced an increase in the number of reports of truancy due primarily to pandemic-related challenges in remote schooling, school attendance, etc. The Office of the Attorney General brought forward concerns that additional language was needed to clarify that OCFS has a role to intervene with families in situations where truancy is the result of neglect and not the result of other issues such as medical concerns, illnesses, etc. And after review, we agreed with their position. So although the pandemic has brought this issue to the forefront, we believe this additional language provides much needed clarity because the statute as currently written indicates jeopardy can be evidenced by deprivation of education without requiring that the deprivation be caused by parental neglect. I urge you to support LD 762, including the proposed amendment. And thank you for the opportunity to testify and happy to address questions that you may have.
Now we'll invite some questions. And for the record, my lights are blinking, so you may be on call, Representative Meyer. I don't see any questions for Dr. Landry. Thank you for being here. Thank you for your testimony. I don't see any, yes, so we want to hear now from Victoria Wallach. If you want to unmute and join us. Welcome.
Thank you. Senator Claxton, Representative Meyer, and members of the Health and Human Services Committee. I am Victoria Wallach, Communications and Government Relations Director for Maine School Management, representing the legislative committees of the Maine School Boards Association and Maine School Superintendents Association in support of LD 762. We, like you, are concerned about truancy and absenteeism, particularly over the last year. Truancy appeared to be on the decline in the first part of 2019-20 school year, but then COVID hit. The Department of Education, through its Maine School Safety Center, has done outreach and education around truancy in Maine for the very things Dr. Landry talked about. We understand there were COVID-related issues, but there were also concerns that we just weren't seeing kiddos and we didn't know where they were. It was the reality that the truancy was very difficult to determine when school buildings were closed, and the online learning that was provided required stable internet and in-home schools. And again, we didn't have our eyes on kids during COVID as much as we would when they are with us. We have worked consistently with the DOE throughout the pandemic on COVID-related issues, and the department has reconvened its Truancy, Dropout, and Alternative Education Advisory Committee. And that includes superintendents, principals, teachers, and representatives from adult education, where students who need credits to graduate often turn. There were also members from the Health and Human Services and Department of Labor on the committee. And this has now been reconvened. This bill adds to those protections around student through this unprecedented time, and particularly into the future, because as mentioned, the COVID is one issue, but the truancy is becoming a greater problem, at least from our point of view, when we look at the numbers. And I'd be happy to take any questions or get information for you.
Does anybody have any questions for Ms. Wallach? Not seeing any. We'll thank you for being here. And I don't see any other folks who want to testify for this or against this or okay, no, neither for nor against. So we'll stop there. That'll conclude the public hearing portion of our consideration of LD 762. Are there any questions that we'd like to ask of our analysts in anticipation of the work session? I don't see any of those either. I do notice that Representative Hymanson is in the waiting room, and she initially asked to go last. I don't know if, why don't we invite her in and see if she would like to join us and testify, or whether she'd still like to go last. Welcome, Representative Hymanson. Oh, you're still on mute. We can't hear you.
You'd
Thank
think
you.
I'd have gotten over that by now. It's a pleasure. I'm going to see if my people are ready. So
Okay.
I'll just put myself back on mute and stop the video, and I'll get back to you.
Well, we'll go ahead then and hear another short departmental bill.
Okay.
Okay,
All right.
great. Representative Meyer, do you want to do your second bill?
Yes. Thank you very much, Mr. Chair. Senator Claxton, esteemed members of the Health and Human Services Committee, I am Michelle Meyer, proudly serving House District 2, Elliott, and parts of South Berwick and Kittery. I was asked by the department to sponsor LD 837, an act to ensure that definitions in the Child and Family Services and Child Protection Act comply with state and local federal law. This bill amends the definitions of abuse and neglect and enacts a definition for child sex trafficking. Dr. Landry will be speaking after me, and I would ask that you direct your questions to Dr. Landry.
Looks like it's your turn again, Dr. Landry.
Thank you very much. Again, Senator Claxton and Representative Meyer, members of the committee. Again, for the record, I'm Todd Landry, Director of the Office of Child and Family Services in the Department of Health and Human Services, here today to help introduce and testify in support of LD 837. As you heard, this bill amends the definition of abuse or neglect in statute and enacts a definition for child sex trafficking within the Child and Family Services and Child Protection Act to bring Maine into compliance with the federal Child Abuse Prevention and Treatment Act, also known as CAPTA. CAPTA requires state child welfare agencies to ensure identification and assessment of reports involving children known or suspected to be victims of sex trafficking. In order to effectuate this requirement, OCFS requires a statutory change to the definitions in the Maine Child and Family Services and Child Protection Act. Sex trafficking is already a part of the definition of abuse or neglect when it is perpetrated by a, quote, person responsible for the child, as defined in statute. Matters involving sex trafficking of children sometimes involve perpetrators who do not meet the definition of a person responsible for the child. This change will therefore ensure the department has the legal authority to intervene in situations where sex trafficking of a child is occurring, regardless of whether or not the perpetrator is considered a person responsible for the child. OCFS brought this proposal forward after work done last year to study and recommend improvements in the state's response to commercial sexual exploitation of children. This work was done in concert with the Maine Coalition Against Sexual Assault and the Muskie School of Public Service. One of the recommendations from that work was that OCFS consider proposing an amendment to statute to ensure child welfare staff have the legal authority to respond in all cases of suspected commercial sexual exploitation of children. For these reasons, I urge you to support LD 837, and I'm happy to answer questions that you may have.
Are there questions for Director Landry? I don't see any, so thank you for being here. Before we go to Ms. Saxel, I want to check in with Representative Madigan, give her a chance to introduce herself and find out if she's going to be around for a bit or have to disappear again.
Hi, I'm Representative Colleen Madigan. I represent House District 110, which is part of Waterville and Oakland. And yes, I'll be around for a while.
Oh, good, good. So Representative Hymanson, if your people aren't available, we can put you at last and have Representative Madigan do some. Before that, I'm still looking for Elizabeth Ward Saxel, who was here.
I am here.
Oh, there you are. Okay. Welcome.
We're good to go whenever you want to fit us in.
Thank you, Representative. So the floor is yours, Ms. Ward Saxel.
All right, Senator Claxton, Representative Meyer, member of the committee. I am Elizabeth Ward Saxel on behalf of the Maine Coalition Against Sexual Assault, as well as here on behalf of Maine Sex Trafficking and Exploitation Network and the Maine Network of Children's Advocacy Centers in support of 837. As Dr. Landry indicated, we worked with the department and the Cutler Institute on a study looking at the state's response to CSEC. Which among its recommendations made that this change of statute happen. Our advocates have seen the challenges that this gap poses for children who are being trafficked or who are suspected of experienced trafficking. There are four main challenges with the current system that the bill would address. One, many mandated reporters believe that reporting suspicions of child sex trafficking to the department will result in an investigation and support for that child. However, by current statute, in many cases, those reports should actually be made to the district attorney's offices. At best, this challenge means delayed referrals to children's advocacy centers. At worst, this means reports of child sex trafficking are unaddressed. Number two, it is unusual for children experiencing sexual exploitation to disclose their experience as such. As a result, CSEC, commercial sexual exploitation cases, may not have known perpetrators, which further complicates the reports. Number three, services available for children experiencing CSEC are limited. We need the department's help. Even in cases where it is known that the child is experiencing sex trafficking and a caregiver navigates the system to receive a proper referral to the Children's Advocacy Center, the services available to that child are limited. The department already has access to a network of resources at no cost to the families that are used in other cases of abuse and neglect. These resources could begin to address the gaps in CSEC services statewide. And finally, DHHS involvement may be needed to encourage programming for kids. You can imagine how difficult it would be to access services without the help of a competent, involved caregiver. Currently, there are not adequate mechanisms without the department's involvement to mandate these services when caregivers are not cooperating with the intervention deemed necessary. You should not be kept from services to support and empower them through what may be the most intense and traumatizing experience of their life. This bill would ensure that youth are able to engage in services necessary for their own safety and healing. This bill alone will not solve the problem of CSEC in our state, but it's a critical next step in our state's response for these victims. I'd also like to just acknowledge how much work the department has been doing in this last year and a half around CSEC. Phenomenal changes to internal policies and practices, just an extraordinary amount of work. When we saw these recommendations come out, we thought, well, maybe in 5 or 6 years we might get through some of them. Man, the department just got right to work and really made enormous progress within a very short period of time. So thank you for your consideration, and I'm happy to answer any questions you might have.
Thank you for your testimony. Are there any questions? I don't see any. It looks like I don't have
Thank you for your
anybody.
time.
Any questions? No. It looks like there's nobody else to testify for or against, or neither for nor against. So we'll go to asking if anybody has any information they'd like of our analyst in anticipation of the work session. And I don't see any hands up there, so that means we're ready to proceed. As long as Representative Madigan is going to be here for a bit, I'm going to defer to Representative Hymanson, as long as she's rounded up her people, if that's okay with you. Welcome, Representative Hymanson.
Thank you. It's a pleasure to see this hardworking committee and be here. I wish I could give you some libations. That will come. But for now, it's just great to see you, and thank you for all your work. Good afternoon, Senator Claxton, Representative Meyer, and the esteemed Joint Committee on Health and Human Services. I am Representative Patty Hymanson, and I represent parts of York, Wells, Sanford, and Olive Ogunquit. I come before you today to introduce LD 606, an act regarding the child protection system. And I come with an amendment to the language. This bill seeks to improve the child welfare system and the safety of children at risk. The section of law we will be considering first authorizes the Department of Health and Human Services to, quote, cooperate and coordinate with other agencies, facilities, or persons providing related services to family and children, end quote. This paragraph that gives the department the authority to communicate. The second section then requires the department to do certain things, and here is where this bill seeks to add requirements. I'll read the amended language, which really simplifies the process and takes away the expectation that the department will coordinate with these entities. The department shall communicate with the various entities that are part of the child protection system, including but not limited to schools, law enforcement, healthcare providers, counselors and therapists, and community services providers. So why, if the law gives the department authority to cooperate and coordinate with community entities, do we need to require them to do this? In 2018, 1-year-old Kendall Chick and 4-year-old Marissa Kennedy were killed by their caregivers and known to the Office of Child and Family Services. At the community level, many people could see pieces of the dysfunction in the family that put these children at risk, but the full story was not pieced together until after the tragedies. OCSF, under the leadership of Director Todd Landry, have approached their work in, quote, appropriate and comprehensive, end quote, ways. This is from the Child Welfare Services Ombudsman Report from 2019. As this committee has likely heard, and I give them much praise. However, quote, two specific areas where children's safety is often at the most risk, and I'm quoting from the Ombudsman Report from 2020. One, the initial investigation of a child's safety, and two, the ongoing assessment of reunification and the decision at the end of a case about whether or not a child should return home to the parents. OCSF continues to struggle in these areas, and there is need for more active and consistent communication in the future. End quote. Again, from the Ombudsman Report from 2020. This new language proposed in LD 606 as amended above would require communication with the community entities. I hope by listening to the testimony of those who follow, this committee will see the need for this requirement. Thank you for your attention and your consideration. I'm happy to answer questions as I can.
Thank you. It's good to see you around what used to be a virtual horseshoe, which is now a virtual horseshoe. Are there any questions for Representative Hymanson? I don't see any, so we can proceed to hear from Deborah Dunlap. If you would unmute yourself and join us.
Senator.
Welcome.
Senator Claxton.
Yes.
I
Oh, I'm sorry.
I'm not seeing Representative Hymanson's testimony. Can you submit that for us, please?
Yeah, I did submit it in the
Okay.
portal, but I'll submit it again.
Thank you, Patty.
Thank you. Thank you, Representative Meyer. Now, Ms. Dunlap, floor is yours.
Thank you, Senator Claxton. Good afternoon, Senator Claxton, Representative Meyer, and distinguished members of the committee. My name is Deborah Dunlap, and I'm speaking today in support of LD 606, an act regarding the Child Protective System. I have worked in the social services field for over 20 years with families who are involved with the child welfare system. And I currently serve on 2 child welfare focused statewide advocacy groups. I'm speaking to you today as a private citizen from Gorham. Community-based service providers are on the front lines of child abuse and neglect prevention. There are many different providers who have regular contact with kids and families, and no one holds the full picture on their own. If child protective workers and community providers don't communicate regularly as a child protective team, child safety can fall through the gaps. In the 2018 OPEGA investigation following the deaths of 2 children in state care, the authors noted, quote, "The risk of child abuse neglect was not necessarily evident without continually putting together many pieces of information held by various parties," end quote. Based on these findings, OPEGA recommended the department take steps to improve communication practices with community entities. So as Representative Hymanson has noted, current law gives the department the authority to cooperate and coordinate with community entities, but there's currently no requirement for any of this communication to take place. LD 606 would require communication between child protective workers and the providers who have the most frequent contact with families in the community: schools, law enforcement, healthcare providers, counselors and therapists, and community service providers. These are the people who see children and families every week, sometimes every day, and the information that they have to share is critical. Child safety is not the responsibility of state government alone. And the stressors the pandemic has placed on families make it even more important for everyone to work together to keep kids safe. Maine's child welfare system has at times been a national leader in community-based child safety practices. And under Dr. Landry's leadership, there have been many new improvements put in place. Yet still, community service providers continue to express concerns that the department's communication practices need to be strengthened and made consistent across cases and across locations. The intent of LD 606 is to enact OPEGA's recommendations and require this essential communication. Thank you for considering my testimony. I'd be happy to answer any questions.
Thank you. And I understand you'll be submitting a copy of your testimony?
That's correct.
Are there any questions from Ms. Dunlap? Not seeing any. We'll proceed to, thank you for being here, and we'll proceed to Melissa Hackett. If you would unmute yourself and join us. Welcome.
Thank you, Senator Claxton. Some of the items I was planning to testify on have already been spoken of, so I'll just get to the heart of the matter aside from those. Save us all some time. My name is Melissa Hackett, and I am the Policy and Communications Associate with the Maine Children's Alliance. I am here on behalf of the Alliance to testify in support of LD 606. Now more than ever, the stressors on families are high, as is the need for meaningful supports to prevent the breakdown of healthy family functioning that can otherwise lead to child maltreatment. Many individuals and entities engage with children and families in their communities, and the issues that can bring children into protective custody require a coordinated response within communities and with state agencies to ensure children and families get the services they need when risk factors are present for abuse or neglect. When community organizations have the opportunity to work together with the Child Protective Agency, children and families have better outcomes. By increasing critical communication between state and community entities, we can ensure children do not fall through gaps created by a lack of adequate communication. We support the intent of this bill to increase that collaboration between the state and community partners who work with children and families. Thank you.
Thank you for that succinct testimony. Are there any questions of Ms. Hackett? And I'm not sure if I saw, were you submitting the print version?
Yes, I'll submit this after the
of your
hearing.
expanded testimony, please? Thank you. Anybody else have any questions? I don't see any. So now we'll hear again from Ms. Wallach. Join us.
Thank you. I am Vicki Wallach, Communications and Government Relations Director for the Maine School Boards Association and Maine School Superintendents Association in support of LD 606. Thank you for having me, Senator Claxton, Representative Meyer, and members of the committee. Our associations support this bill because communication it requires could literally save a life, as was mentioned. It's hard to forget the tragedy, and we're all going back to 2018 kind of era. There were some terrible, terrible tragedies then. And one that stuck out for us because we were in touch with the sending school was when in the Stockton Springs killing, when a 10-year-old girl was killed by her mother and stepfather. According to reports at the time, the child suffered months of physical abuse leading to her death. The parents were ultimately charged. Before the child moved to Stockton Springs, she attended school in Bangor, and the school staff had made numerous reports regarding abuse to DHHS, and they were responded to. So it's when she moved and fell off the radar screen that the girl died. Statistics support that teachers and other school personnel are key mandatory reporters on child abuse. There is no way to say with certainty that the communication required in this bill would have saved the girl's life or other children, but we have to believe it would make a difference. And we are in support because we know that we can sometimes be the link because we see these kids or we notice that they're not there anymore. And if we make the call, it can make a difference. So we support and thank you for your time. I'm happy to take any questions.
Thank you for that. Are there any questions of Ms. Wallach? I don't see any. Thank you again. So that brings us to Director Landry. Do you have some thoughts on this bill?
Yes, thank you very much. And and again, I'm Todd Landry, Director of the Office of Child and Family Services in the Department of Health and Human Services. And while the department does not take any position on this bill, we did want to share some information with the committee, and that is provided in our submitted letter. And while we certainly appreciate the intent of the bill, and while we are always committed to communication as appropriate, we do have some concerns regarding confidentiality. And it is important to note that regardless of intentions, one of the things we cannot do and should never do is, of course, violate statutes regarding confidentiality that have been enacted by you and your predecessor colleagues. And so we do have concerns about confidentiality related to this and the potential position that this statute could put some of our caseworkers in. In addition, I think it's important to note that we also have some concerns about the impact of this bill if implemented on the working relationship with clients, either by OCFS or providers. We believe that's an important consideration as you consider and deliberate on this bill. But thank you for your time.
Thank you for your testimony. Are there any questions? Yes, Representative Perry.
Thank you. I guess my question for you is, knowing how this girl fell through the cracks, that you have been working with the family and suddenly they're in a different jurisdiction and there was no communication within the department that this girl had moved and there were family issues. And I guess my question for you is, what are you doing now to try to solve that issue?
Well, thank you for your question, Representative Perry. I appreciate it very much. I believe there are a number of things the department has and continues to do as we implement a number of recommendations that were included in the PCG evaluation and others in the following some of the situations of high-profile cases in 2018. So among the things that we are doing is, as you may have already heard in previous discussions, We're currently working with the Muskie School right now and making changes to our training for initial caseworkers as well as ongoing training. One of the pieces that is a significant discussion around that is communication and how to appropriately share communication while still ensuring that we're following all of the confidentiality statutes. And so I do believe with the number of staff that we have, it's important to make sure that we train our staff very carefully on what statutes give us the authority to do and where we can work within the parameters of those statutes in order to ensure information is being shared. That's certainly one example. That training extends not just for caseworkers, but of course to our supervisors who are working with our caseworkers and all the way through the organization. As I said in my brief comments, we're in full support of the concept of sharing as much information as possible. We just want to be clear that we cannot do that outside of the statutory limitations and requirements that we all have to follow regarding confidentiality, whether it is us in OCFS or on the part of providers.
Can I ask another question?
Please follow up. Yep.
Yeah, I guess my concern is the ability and what are the things, the confidentiality things that prevent one caseworker asking another caseworker to follow up on a case that has moved out of her area.
To answer your question, there's nothing within caseworker to caseworker. There are limitations that we can share, for example, with school staff. There are limitations on what we can share without a release of information to providers. There's, obviously limitations when you go outside of, in this case, using this example, OCFS. Nothing is prohibiting us from sharing information on that. And while I can't speak because of confidentiality, I can't speak to the specifics of that case. I can tell you that information sharing, happens on a, daily basis because we do know that, that families move, they change locations, and we have to be able to adapt and follow up on that. One of the big challenges that we see with this bill is as it relates to potentially, and I know that Representative Hymanson indicated an amendment was coming, but as we currently read this bill, we believe there are challenges regarding sharing the information outside of OCFS with, and the potential conflict that this bill currently says about sharing with providers, for example, or school staff or others, that would potentially put our caseworkers in a conflict situation of saying you got one statute that says share this information with providers, et cetera. We got another statute that says we can't do that without violating confidentiality. We don't want to put our caseworkers in a position of potential conflict in those situations.
Does that answer your questions? Very good. Representative Madigan?
Thank you. Director Landry just answered my question. Thanks.
Great. Representative Zager?
Thank you, Mr. Chair. And Dr. Landry, I really appreciate your thoughtful testimony on this. In the case of HIPAA and the federal legislation, there's certainly, confidentiality is certainly dealt with, and there are safety valves and exceptions that are natural carve-outs. Are there not such carve-outs for the statutes that you're referring to, and presuming there are you does your department find them unwieldy or unworkable for the purposes of protecting children and communicating?
Yeah, thank you for that. Certainly there are opportunities and ways that you can, the confidentiality provisions are waived, such as, active consent by those that are being discussed or the subject of the discussion. And so there are appropriate safety mechanisms in place. I don't believe personally right now, based on what I've seen, that I'm seeing any significant restrictions of our ability to share appropriate information where needed. Again, we operate strictly within the confines, but we do have a significant amount of latitude within those parameters or sidelines, so to speak, in order to be able to share that appropriate information Or we can be very clear in being able to say, we cannot share that information unless we have a consent. And then we go through the process of actually getting that consent to ensure that we are not, in fact, violating any confidences. So I believe we have the ability to do this now. Again, the PCG report, as I read it, I respect and appreciate the work of PCG. I will tell you this comment about communication in the PCG report is bluntly in every single PCG report I've read, whether it's about Maine or any other state. And it's a good thing for us all to keep in mind. We all want to be able to communicate and share to the greatest extent possible. And it's a great aspirational value. But I don't believe we have anything in restricting us from being able to do that appropriately and within the confines of Maine statute currently.
Are there any other questions of Dr. Landry? I don't see any. Thank you for being here. Are there any questions for Aaron in anticipation of the work session? Don't see any there either. So we'll move on. So the Representative Madigan, you can pick which of your bills you start with, and we'll just go with you.
Thank you. I'm going to start just because I think it will be quicker. LD 760. And that, hold on. Okay, that is a bill. My Zoom screen just cut out. I don't know why, but I can. So LD 760 is an act to clarify the disclosure of records under the Child and Family Prevention Services Act and Protection Act. So this was a bill I put in for the department, and it just has to do with how records are shared, information is shared, and those records by third parties and things like that. I think folks will come after to testify, and I think a lot of this will be worked out in work session. So there's that one.
Okay. Looks like Director Landry, it's your turn again.
Yeah, thank you very much. And good afternoon again, Senator Claxton, Representative Meyer, members of the committee. My thanks to Representative Madigan for introducing the bill. I'm Todd Landry, Director of the Office of Child and Family Services in the Department of Health and Human Services, here today to help introduce and testify in support of LD 760. As you heard, this bill would amend the confidentiality section of the Child and Family Services and Child Protection Act to clarify that the department may limit disclosure of records to only those created by the department in connection with our child welfare duties. So allow me to explain why we believe this is important. LD 760 is our department-initiated bill that we propose due to, in part, the thousands of requests for records we receive every year. These requests range from Clifford orders, those are court orders for the department to produce records in non-child protective litigation, to requests by individuals to review their own records and those of their children. Due to the nature of our investigations and our work on rehabilitation and reunification, our records frequently contain a significant amount of information originated by providers and not OCFS staff. Examples of these would include medical records, school records, substance abuse treatment records, and criminal history information. Currently, the statute places no limitation on what is considered a part of the record for the purpose of disclosure, and as a result, OCFS is releasing the entire case file, including both records produced by OCFS staff and provider records gathered in information investigations and case decisions. These provider records frequently contain highly confidential and sensitive information regarding the parents and children involved with OCFS. They are records provided to OCFS as part of a child protective matter, and most clients likely never anticipate the release of records beyond OCFS. Individuals who are concerned about the inclusion of provider records and information released by OCFS may be less willing to work with OCFS and provide access to critically important provider records needed to make child safety decisions. In addition, OCFS cannot attest to the completeness of the provider records in our files. For example, OCFS may obtain a record today, and tomorrow the individual who is the subject of that record may seek additional care that causes the record that our staff obtained to now be obsolete. Significant gaps in information is very likely, given that often records are requested that are several months or even several years old. Now, I want to be clear. This bill is not seeking to eliminate or reduce access to provider records, but rather requiring that those who need those records obtain them directly from the provider. This will ensure the record that they receive is up to date and accurate, and that the legal standard for the release of that information has been met. Generally, that there be an explicit release of the information by the client or the client's parent. We recognize that using the department as a conduit may be easier for those seeking records, but in this situation, we believe the privacy interest of those whose information is contained in these sensitive records outweighs any need to obtain provider information via the department. If LD 760 passes, OCFS will certainly continue to provide records originated by our staff when we receive a request for records that meets the requirements of the confidentiality statute. I'm happy to answer questions that you have on this bill. I urge you to support LD 760, and thank you for the opportunity to be with you today.
Does anyone have any questions for Dr. Landry? I don't see any. Thank you. I don't see anybody else to testify either for nor against. And are there any questions we'd like to have answered by the analysts or addressed before our work session? Again, I'm not seeing any. So we'll go back to you, Representative Madigan, for LD 493, 97.
Thank you, Senator. Good afternoon, Senator Claxton, Representative Meyer, and my fellow members of the Health and Human Services Committee. I'm Representative Colleen Madigan, and I represent part of Oakland and part of Waterville. I'm here today to introduce LD 497, an act to strengthen supports for families and children through a child abuse and neglect prevention and early intervention program. This bill comes out of a combination of concerns of a constituent, a study I read that came out of Michigan, contact with other constituents, and what I see happening now. Last year, I got a call from one of my constituents. She has 4 young children, including a son born in February 2020, just a month before the pandemic struck. She's a dedicated mother. She's also an Educare parent ambassador and a passionate advocate for issues she cares about, particularly those involving children. She's come to the State House before to advocate, including in front of our committee, including the last day we were in the State House last year. That was the day I got to meet baby Sebastian, her newest child. He's adorable, by the way. In the fall, I got a call from this mom. She was angry and upset. She had been caring for her infant son and raising 3 other children, trying to help them with remote learning and days in school. Her husband works, and she had had difficulty finding work that would fit with her family's needs. One of her children had missed days of school, and the school had made a report to Child Protective Services. A child protective worker had shown up at her door. No, I am not criticizing. I want to be really clear about this. Child Protective Services or the school. But it occurred to me that every parent that I knew was overwhelmed, just like this mom. Although she is a rock star, this mom wasn't unusual, and schools, service providers, and child welfare staff were also overwhelmed with concerns due to the pandemic. Ultimately, the situation was fine. Child Protective Services closed the case with no findings, but it got me thinking about what was going on. I read an article about how Michigan had used existing resources to create a sort of outreach and prevention model by reaching out to families, asking them what they needed during the pandemic. They recognized that families were overwhelmed and isolated, and connecting them with resources could prevent further problems down the road. This kind of outreach also validated those overwhelmed feelings that people were having. I know we were moving towards the tail end of the pandemic, but we need to acknowledge the toll it has taken on everyone. Perhaps because I am a social worker, I see the looming mental health crisis. Most people, but especially parents, have been struggling to do it all and do it all by themselves. I think creating a way to do more outreach and connection is something we need right now, and it is a way to prevent child abuse and neglect. Originally, when I put this bill in, I thought that using alternative response programs was a good way to do this. OCFS has made changes in this area of alternative response program contracts, but that doesn't change what I see as a need for families in Maine. I am absolutely supportive of the department's focus on implementing the Families First Prevention Services Act plan. However, if you look at the federal clearinghouse for approved interventions for this act, you will see models focus on treatment and intervention, not prevention, in spite of the name of the act. This is not a shortcoming with our Maine Department of Health and Human Services and OCFS. This bill aims to fill that gap by focusing on outreach and prevention. I've had extensive conversations with stakeholders in community services and with parents. We have some people with experience in providing these kinds of services. We're working on an amendment to this bill I think will work. And I've also had conversations with the department about what my intention is with this and the changes just in the alternative response program contracting. I look forward to working this bill in work session and would be happy to answer any questions.
Thank you, Representative Madigan. And are there any questions for her? I don't see any. So we also have testifying for is Ms. Hackett. If you want to take yourself off mute and join us.
Hello again. I'll be a little less brief this time, so glad you appreciated it the first round. Hello again, members of the Health and Human Services Committee. Again, I'm Melissa Hackett, and I am testifying in support of LD 497 on behalf of the Maine Children's Alliance. We strongly support the urgent need for a focused primary prevention and early intervention program. Incidences of abuse and neglect, as well as children coming into state custody, were already high before the pandemic, which has only exacerbated stressors within families. Even as important investments have been recently made in Maine's child protective system, an upstream investment in primary prevention is needed now to help stabilize families. Cases represent symptoms of larger issues families are struggling with, as well as insufficient supports to prevent the breakdown of healthy, functioning families. When children experience maltreatment, they experience trauma, which can have a profound and negative impact on the healthy development of children. It is our responsibility to make best efforts to support families and reduce the number of children in Maine who experience this trauma. It's critical right now we not lose sight of the vision and goals of prevention work in our state and ensure the landscape of services and providers in primary prevention with families is robust, readily available, and accessible. Nationally, new attention and investment is being directed toward primary prevention, such as the federal effort Thriving Families, Safer Children, as well as the initiative in Michigan that Representative Madigan referenced. I think it's also helpful to consider this prevention continuum of services in three distinct areas of focus: primary prevention, or the front yard, secondary prevention, or the front porch, and tertiary prevention, or the house. This last area is the focus of child protective services, as well as family first prevention services. OCFS should be commended for its work in responding to the opportunity Family First provides to increase evidence-based intervention for children and parents where abuse and neglect has been indicated. Yet creating that plan highlights a gap in services for prevention and early intervention. If we are focused primarily on services for families once abuse or neglect has already occurred, it is unlikely we will reduce the number of children who experience maltreatment. To do that, we need to focus resources for children and families who are on the front porch and in the front yard of child protection. Lastly, I would echo the real urgency and timeliness of this legislation. The risk factors of parents and children have been exacerbated during the pandemic. These additional stressors within families underscore the need to respond. Families are struggling. With significant additional federal relief coming to our state, now is the moment to utilize newly available funds to stabilize and strengthen families so children are able to thrive there. Thank you, and I'm happy to answer any questions.
Thank you for that testimony. Are there any questions for Ms. Hackett? I don't see any. Thank you again for being here. And next we'll hear from Dr. Landry.
Yeah, thank you again, Senator Claxton, Representative Meyer, members of the committee. Appreciate you having me again to be able to provide some testimony on this bill. I'm Todd Landry, Director of the Office of Child and Family Services within the Department of Health and Human Services, and here today to testify in opposition to LD 497. This bill would establish a prevention and early intervention program to provide services to families when a child is at risk of abuse or neglect, including those for whom a mandated reporter has concerns that do not rise to the level of requiring a report to the department. OCFS's statutory duties contained in 22 MRSA Section 4004 require the department to act to protect children who are abused or neglected or are at substantial risk of abuse or neglect. The eligibility section of this proposed bill would not just include families who have been involved with child welfare through an investigation, but also any family referred to the program by a mandated reporter when the mandated reporter has concerns that do not rise to the level of a report to the department. The only requirement is that the mandated reporter believes the family is in need of additional services. If a report to the department is not warranted, it is unlikely that the circumstances would rise to the level of being considered a, quote, substantial risk of abuse or neglect as required in current statutory authority. Furthermore, this bill, as you have heard, proposes the continuation of the current alternative response programs, which are the subject of a pending proposal. We appreciate the discussions with Representative Madigan and understand a amendment is coming with regards to that piece. It is important to note that under Family First, as you've heard, these reports that are proposed under this bill would very likely not meet Maine's definition of candidate for foster care under the Family First requirements. So that would mean that Maine would not be able to receive any federal matching funds under those current contracts or proposed contracts, excuse me. It's important, I believe, to note that there's no limit in this bill on the amount of time a family may receive the service. Due to the broad eligibility requirements for this program and the open-ended nature of the service, the fiscal impact of this proposal, we believe, will be quite significant. The eligibility criteria for this program are such that essentially any and all families in the state could be referred. OCFS is concerned about investing heavily in a program that is not evidence-based and lacks an evaluation component to examine the impact and effectiveness of any services provided. The program required by this bill would require OCFS to deliver primary prevention to families throughout the state, which you have heard from some of the other testifiers today. We believe this exceeds the mandate of OCFS's Child Welfare Division, and in our experience, primary prevention efforts have the greatest impact when they're provided voluntarily and without direct public involvement within communities by local providers, including schools, community organizations, faith-based organizations, and primary healthcare providers. So we appreciate your consideration of these concerns. We thank you for the opportunity to testify before you today. I'd be happy to try to answer any questions that you might have.
Are there any questions for Dr. Landry related to this bill? I don't see any. Are there any questions related to this bill for Ms. Dooling? I don't see any there either. Okay, so that there's nobody else who wants to testify for or against. That concludes the 6 bills that were on our agenda for today. Are there any other items of business to come before the committee at this point? I see the people who should know are shaking her head.
Yeah, not that I know of.
Okay. And so we will reconvene Health and Human Services on April 1st, Thursday at 10 o'clock for a series of public hearings that will run into the afternoon.
And that's not April Fool's Day.
Thank you, Senator Moore. No, that's the truth. That's the truth. Okay. All right. Well, it's good to see everybody. I'm glad nobody went away during the committee hearing and lost power, and I'll cross our fingers until the winds calm down.
Have a safe journey. Have a safe journey to Augusta, everyone.
Yeah. Be
Yes,
safe
see you all
traveling.
tomorrow. Say.
Take care.